So at this time, I think that we see no more public comment in the room. We can move to comment via Zoom. Again, if you want to comment via Zoom, please raise your hand. And Kristen, are we ready? If you could give us a few seconds as we work on technical issues.
Yes, so I think we're ready. I'm going to activate the first person. We're trying to deal with some feedback issues that we had heard from Zoom participants. So
Kristen, I'll kill all the mics in the room and let you manage any of the Zoom for the next 10 minutes.
okay, thank you. So
yes, thank you. I hope you can hear me okay. I intend to file a comment, but I had two questions for the working group. May help inform my comment and may help inform the commission's thoughts on this. First, I noticed that there's very little discussion, maybe even no discussion, of the standards for attempted monopolization in your comments. And I think that, Section 2's reach into attempted monopolization at least potentially addresses some of the limitations you see in Section 2 of the Sherman Act. I think you do have a attempt prong in your proposed language, and I think that's important. But I think it'd be fair to fairer or clearer, let's say, to identify why the current Section 2 law is not sufficient, given the attempted monopolization prong as well as the standard monopolization prong. And then in going to your proposed language, you use the term risk instead of probability, and I just wonder what the thinking is behind that. In general, antitrust law, whether it's Section 2 or Section 7 law, tends to use the probability language and not the risk language. And I'm wondering if you see those as different, setting up different standards, and if so, why you propose something that looks a little bit different than common practice.
Kristen, it sounds like the public comment is concluded. Please bear with us. We're working on a technical issue.
is your comment complete?
Yeah, yes, I'm sorry, my comment is complete. Thank you.
So the next speaker is Bianca Blomquist, and I'm going to allow Bianca to talk.
Hi there. Thank you so much. Thank you for inviting me to speak about the critical importance of ensuring that California's marketplace is fair and equitable, especially for small business owners. On behalf of America's 33 million small businesses and the 4 million small business owners in California, we do recommend that single firm conduct standard that incorporates a broader view of potential harms. To demonstrate why, my comments will focus primarily on marketplace competition and increased consolidation impacts for small business owners in the areas of tech, on the supply chain, and in healthcare, which is a top issue for small business owners, as Anthony alluded to some of the hospital healthcare consolidation issues we'll be discussing today. So this is by no means a comprehensive review of how these anti-competitive behaviors impact small business owners, but I do look forward to working with the commission, and I want to echo the gentleman that was commending the working group on its work to date and here today. And I look forward to shining more light on how these anti-competitive practices impact small businesses. I am Bianca Blomquist. I'm the director of California for Small Business Majority. We're a national small business organization. We empower America's entrepreneurs to build a thriving and equitable economy. At Small Business Majority, we engage our network of almost 100,000 small business owners and 1,500 business and community organizations to advocate for public policy solutions that promote equitable small business growth. Robust market competition is essential to a thriving small business ecosystem. A level playing field can boost healthy competition between small and large businesses. This promotes more competitive prices and business terms as firms are regularly buying from and selling to larger companies. For example, small businesses depend on some key online platforms to market and sell their products and services. In fact, 57% of small businesses rely on such tech platforms to sell their products and services. So as these tech platforms continue to take over in the marketplace, they can charge pretty excessive fees, high prices, and sometimes impose onerous commercial terms, which effectively prices small businesses out from the competition. We see this play out among some of the biggest tech platforms, such as Amazon, Facebook, Google, etc. Likewise, small businesses depend on critical supply chains to create products and support the services that they offer. Suppliers are charging high prices and imposing pretty unfair business terms, which effectively leaves small business owners without any alternative options. The same applies to components in the product distribution process, shipping and transportation, etc. Another example of excessive monopolization that's causing indirect economic hardship to small business owners is the lack of competition within the hospital industry. This is a piece that Anthony was discussing in his comment to you. When hospitals in a geographic area crowd out the competition, insurance companies are essentially compelled to include them in a coverage plan. The rates are dictated solely by that monopolistic entity. Hospitals are also buying outpatient facilities and physician practices to drive up prices through vertical integration. These large consolidated hospital systems are using increased market power to drive those costs through anti-competitive contracting and billing practices. Those excessive costs are passed down to small business owners and the employees who work for them, forcing them to pay for overpriced care. I mentioned we are an advocacy organization that relies on scientific polling and research. Our polling found that 80% of small businesses say that large businesses have too much control over the markets that allow them to take advantage of small businesses, and that the role that the government has to help create a more equitable playing field. And small business owners are strongly supportive of a number of bipartisan solutions being considered in California that would tackle rising costs, level the playing field, and increase competition, especially within the hospital and pharmaceutical industries in particular. Small business owners believe that healthcare providers should be required to publicly post the prices they charge for services, in addition to their support for a government ban on facility fees and unfair billing practices. They support setting limits on what hospitals can charge for particular services. We're working very closely with the Office of Healthcare Affordability on these. And they also support greater authority to block mergers and acquisitions in the healthcare industry. In our polling, we found that 76% of respondents agree that healthcare provider consolidation should be prohibited if there's no demonstrated benefit for the consumer in health or cost outcomes. AB 3129, for example, will address rising costs in the private sector that have impacted every aspect of the system, including raising premiums in the public sector for small business owners. And pulling on a thread that Professor Richmond shared on market consolidation in the prescription drug and pharmacy space, I wanted to share that I live in Sonoma County, I've been a client of a company called Tuttle's Pharmacy since I moved here years ago. Weeks ago, Tuttle's Pharmacy announced that it's going to close its 2 locations in Santa Rosa, ending nearly 8 decades in business. Tuttle's Pharmacy has been one of the oldest continually operating locally owned businesses in Santa Rosa. As a result of independent pharmacists' increased inability to compete against the radical integration happening in the pharmaceutical industry, this independent 3rd-generation family-owned pharmacy has been sold to Rite Aid, where Robert Tuttle now works as a pharmacist. So again, this is why we applaud the commission for recommending the addition of prohibitions on single firm conduct in the Cartwright Act, and the absence of prohibition on monopolizing single firm conduct is the most glaring deficiency. Those 3 improvements the report could make: recommending single firm conduct standard incorporate a broad range of potential harms. Second, the commission should articulate an alternative to the rule of reason framework, and the commission should account for vagueness in the law by granting rulemaking authority to an expert administrative agency. In short, small businesses depend on a healthy and robust competitive environment to conduct business and survive and provide quality jobs. Thank you so much. I'm happy to answer any questions, and I look forward to working with this working group and the commission on future reports.
Thank you.
Kristen, is there anyone else?
Yes. So the next speaker is Peter Leroux Munoz, and I am.
Great. Well, good afternoon. Thank you for having me. My name is Peter Leroux Munoz. I am representing the Silicon Valley Leadership Group, a business association that represents over 200 companies, startups, and research organizations in the innovation economy. You've heard concerns raised by small business leaders as well as other business leaders, and we echo many of those concerns, so I will keep my comments brief, building on those. While we understand the need to ensure a competitive playing field within our markets, we're concerned that this study proposal would, if adopted, produce real-world harm for consumers and businesses in California. Our state's existing laws have served California's citizens well for more than 100 years, supporting the development of the world's most innovative economy. Our businesses have grown alongside the state, making California a world leader in many fields, from technology, medicine, and entertainment to emerging fields such as artificial intelligence and autonomous vehicles. As the Attorney General office can attest, our state and federal antitrust enforcers have used our current laws to great effect to ensure California consumers receive the best products in the greatest number at the lowest prices. California also enjoys robust private antitrust enforcement. Antitrust law has legally and historically been appropriately focused on consumer protection. However, the study proposal here looks to shift that focus to business competition. We fear these changes would harm California businesses, consumers, and workers alike, increasing costs, reducing quality, and discouraging innovation. Consumer protection, including access to and costs for services, should remain the goal of antitrust law. Thank you.
Thank you.
So for the next speaker, I just have a first name. It's Michael, and I will allow Michael to talk now.
Hello, can you hear me?
Yes.
Hello, thank you. My name is Michael Swerdlow, and I'm the Anti-Monopoly Director of the Democracy Policy Network. My comments are solely my own. I worked with a coalition of workers, consumers, and independent business groups that collectively represent millions of Californians to submit proposed legislative updates to the working group's conduct standard. Sadly, those proposed reforms were not considered substantively at this hearing. We did hear today that the working group's conduct standard centers harms to workers and consumers. But to be clear, harms to workers and consumers is explicitly not a cause of action under the working group's proposal without harm to rivals. It is only to be considered in the rebuttal step, meaning that workers, consumers, and independent businesses are locked out of the court explicitly by the working group's proposal, unless they can first show they are harmed in a way that also happens to harm the firm's rivals. This would lock consumers and workers out of court unless they can also show harm to firms' rivals. We also heard that this anti-competitive exclusion of rivals was the primary purpose of the Sherman Act. This idea is at odds with both the brief text of the Sherman Act and much of its legislative history. Senator Sherman and others understood exclusion of rivals as an intermediate goal to prevent what he identified as the primary purpose of the antitrust laws, and I quote, unlawful combinations. In 1890 on the Senate floor, Senator Sherman was extremely clear that unlawful combinations can control the market, raise or lower prices, disregard the interests of the consumer, dictate terms to transportation companies, and command the price of labor without fear of strikes. California needs a law that centers that evil, not just harm to rivals. Californians for a Fair Economy has submitted such legislative proposal, and I encourage the Commission to review the updated legislative text that has been submitted by workers, consumers, and independent business groups. Updates to the proposed statute would prohibit monopolization more broadly, along with unfair competition, which is already prohibited under California law. We'd give an expert body the power to study conduct and create clear rules of the road, instead of delegating that authority to generalist judges that typically lacked antitrust or economics experience to engage in ambiguous balancing that can last for years on end. I strongly encourage each of you to consider the legislative updates proposed by the Coalition of Workers, Consumers, Independent Business Groups of California that reflect the original Anti-Monopoly Coalition. Thank you.
Thank you.
So the next speaker we have is Mike Rayborn. Mike, you are allowed to talk.
Good afternoon, all. My name is Mike Rayburn. I'm a researcher at the California Nursing Association. I thank the Commission and all the expert speakers for being here today. It's been a great to listen to. I wanted to share with you all the perspective of registered nurses on the issue of consolidation in the hospital industry. For nurses, hospital consolidation has been a major problem for years, not only in terms of patient well-being and the broader community, the health of the broader community, but also in terms of labor market dynamics for nurses. Professor Richmond earlier did a great job of laying out the extraordinary level of consolidation in the hospital industry, both nationally and in California. He mentioned numerous studies have shown that hospital consolidation results in significant price increases with little or no evidence of improved care. As nurses, our members understand that higher hospital prices driven by consolidation have dire consequences for patients, for our communities. According to the California Healthcare Foundation, more than half of all Californians overall, and nearly 3 in 4 Californians with low incomes skipped or postponed needed medical care due to costs in the past year. More than a quarter of all Californians and nearly half of all Californians with low incomes report struggling to pay their medical care. Many in California are struggling due to high hospital costs. I also want to emphasize the importance of addressing the impacts of so-called cross-market hospital acquisitions. These types of transactions, which involve hospitals being purchased by systems from outside markets, have been largely ignored by regulators in the past because they do not alter market share of markets, neither end of the transaction. However, there's been a number of studies that have shown that cross-market acquisitions do in fact result in price increases, and they increase in hospital bargaining power with health insurers and other payers. Cross-market hospital acquisitions are likely to be the most common type of transaction going forward. We need to make sure that regulators have the tools they need to meaningful impacts. One other point I'd like to briefly bring up is the high degree of labor market concentration for nurses that has resulted in hospital consolidation. In the Bay Area, for example, 2/3 of all nurses who work at general acute hospitals are employed by just 3 hospital systems. That level of concentration can and does lead to an imbalance in power. Going forward, we will need to make sure that labor market concentration is an important consideration when we look at hospital consolidation and how to remedy their harmful. Appreciate your time. Thank you.
Thank you.
The next speaker is Solana Rice. Solana, you've got speaking privileges now.
Thank you. Hi, welcome. Oh, there's really bad. Hi, thank you to the commission. I hope you all are hanging in there. I know it's been a long day. I'm Solana Rice. I am co-founder and co-executive director of Liberation in a Generation. I appreciate the opportunity to provide public comment on concentration in California, and thanks to all the hard work of the commission. Anchored by our commitment to racial justice and our economic worldview, Liberation in a Generation recognizes that rigorous antitrust enforcement is an important tool for protecting the economic lives and political power of communities of color. Current antitrust policies center around the ideals of perfectly competitive markets and race-neutral policies. And unfortunately, this too often misses that concentration, monopsony, unbridled corporate power have profound effects on people of color as consumers, as workers, as entrepreneurs, and as residents overall. Indeed, the profit and concentration of companies is enabled by the theft from, the exclusion of, and the exploitation of people of color. This results in harms that are not incidental. These are actually necessary for concentration and unbridled corporate power. In order to reverse these effects, we encourage the commission to consider tending to a set of principles when considering concentration and any other dimension of corporate power. Those include ending monopoly power overall, shareholder primacy, extractive financial markets, corporate capture of goods and services, and our democracy, and building worker power. These principles are an effort to remember that people navigate markets, and the people, often workers, drive economic markets. As the commission considers public input on the 7 expert reports and prepares its final report to the legislature and the governor, we urge for the inclusion of proposals that explicitly address impacts on people of color, particularly Black and brown workers, consumers, small businesses, and communities from corporate exploitation. Our first recommendation is establishing a practice of race impact analyses in California's antitrust strategies to enable policymakers and regulators to better identify and address the harms caused by corporate practices beyond just unfair pricing and competition issues. And this is in line with what Professor Steinbaum noted earlier. California can be a first mover in this regard. A race impact analysis will provide insight into the many dimensions of corporate concentration disproportionately impacting people of color. And those impacts include things like monopsony, restricting access to essential goods and services, weakening democracy, and stifling innovation and entrepreneurship. Joining our colleagues at Economic Security Project California and several others in a response letter to the commission, we agree that the lack of prohibition on certain types of single firm conduct in California is an area that should be addressed in the commission's final report. Ultimately, through its own unique policy prescription, the legislature should move to comprehensively fill in this blind spot in the state's corporate harm approaches. In particular, we agree that the state should holistically address harmful conduct rooted in an abuse of dominance or unfairness standard. We also agree and urge the state to provide the Attorney General with rulemaking authority to better and more timely identify, define, and address corporate power abuses that violate these standards, while also providing another accessible avenue for the public to provide their views, insights, and suggestions. Additionally, we recommend not just casting aside the New York 21st Century Antitrust Act. It is a model for modernizing and more holistically addressing corporate power issues in California. It's broadly supported by nearly 75 national and state anti-monopoly business union leaders and racial, economic, and social justice groups. The legislation features critical provisions to cover anti-competitive acts by a single firm harming competition. It expands the threshold for when corporate conduct may be harmful to competition and provides additional oversight of mergers and acquisitions to the Attorney General. And lastly, it really offers significant protections for workers harmed by overly concentrated labor markets. In short, and this is in counter to an earlier commenter, antitrust law can and should be a tool of advancing racial justice. Thank you for your time and consideration.
Thank you.
Thank you. And the next speaker is Terry Ollie.
Thank you, everyone. It has been a long day. Appreciate the time to be able to address you today. My name is Terry Ollie. I'm the Director of Economic Security California. We're an organization that works to build an economy where everyone has the freedom and stability to thrive. We're also part of a California Alliance for a Fair Economy, which has come together, labor organizations, advocacy organizations, racial justice organizations, consumers, come together in support of a set of recommendations on how to update and improve our antitrust laws that will benefit consumers, workers, small businesses, and communities. And we've submitted a letter specifically on the single firm conduct report from the working group today for today's meeting, and recommends consideration of a broader set of harms, which some of my colleagues have detailed and outlined and are in the letter, so I'm not going to go into details here. There's obviously a tremendous amount of expertise in the room today, and the presentations and discussions have detailed corporate concentration in pretty much every market sector in the state, as well as the resulting impacts. We've heard also about the inadequacy of our current tools and proposals for change. And I know it's going to take a while to sort through all of it. So I want to thank you in advance, Commission, for the work ahead. So I want to take this time just to pull up for a minute and put all of this in context of like why we're here at all. And that context, of course, is the growing bipartisan consensus that the status quo legal framework has led to disparities, it's led to dysfunctional markets, and it's also led to, I would call discouraging, this discouraging chance for those who'd like to actually challenge it, because there are a few options to address it. Of course, these impacts, as my colleague Solana just pointed out, are disproportionately felt by people and communities of color, whether that's as consumers, workers, or small businesses, or whole communities. In short, the status quo is just not working, and we have the opportunity to change course and chart a better future where California can boast an economy with actually competitive markets. So the consumers, workers, small businesses, everybody has actual real options and choices in all of our economic sectors. I think it's also really important to point out even a broader context, which is to say that the last 40 years have really been quite the anomaly in our country's approach to corporate concentration. I am always shocked by this, but in 1966, the Supreme Court blocked a grocery store merger that would have, in the LA area, that would have given the merged company 7.5, less than 10% control of the grocery market in Los Angeles. It is astonishing in our modern moment to imagine that when we compare that to the levels of concentration we heard about today in food processing, warehousing, healthcare. And we haven't even touched on tech, which I know there's a whole meeting dedicated to, but just to point out that right now, 3 giants, Amazon, Microsoft, and Google, own the most resource-intensive part of the AI infrastructure stack, as well as most of the large models on which all the stuff that we encounter in AI are built. This means that there's a mere handful of companies that frankly just have outsized control over what gets developed and what makes it to the market. And what bottom line, it just means power. And this is the kind of power and how it's wielded was highlighted actually in the letter that was submitted to you for this meeting today from former Assembly Member Jordan Cunningham, who cited Google's recent credible threat to cut off news to all Californians in basically a fit of pique. This is an unbelievable move, really, except for that Google's dominance in the space actually means that it could do it if it wanted to follow through. And it's the kind of flexes like this of extreme power that are driving, again, a bipartisan consensus and a real shift in how we approach the status quo and our belief that it's not working. Indeed, the resolution that launched this very commission process, ACR 95, was co-authored by a Republican, Jordan Cunningham, and a progressive Democrat, Assemblymember Buffy Wicks. Federal proposals like the Klobuchar and Grassley's American Innovation and Choice Online Act, also bipartisan. This is really a growing consensus, and anyone who's saying that the status quo is working is frankly just outside of the mainstream understanding of what's happening right now. The current framework doesn't work to address the problems, and that's why we're here, of course. The standards are unclear, the burden of bringing a case is untenably high, we heard all about that today, and the resources required are frankly just well beyond the reach of most workers and small businesses and even most government agencies. The decision to bring any kind of, to address any one of these corporate concentration situations is frankly quite extraordinary, and it comes at the cost of pursuing many other things. A broad alliance of organizations has come together to propose a better way, and I just want to refer you back again to the submission on single firm conduct that we brought to you today. And in closing, I'd just like to frankly ask you to seize this opportunity. It is a moment in California where we have an opportunity to restore competitive markets, to ensure access to recourse, and to foster an economy in a California where there's shared growth and prosperity for everyone. Thank you.
Thank you. Thank you.
The next speaker is Bruce Wick. And you're now allowed to speak.
Hi, thank you. Can you hear me?
Yes.
Thank you. Bruce Wick, I just want to add I think an unspoken missing piece of this discussion that I think is important, and encourage us as we go through this process not to have unintended consequences. And I'll give you a quick example of what I'm talking about. I work with the construction industry, a lot of contractors, and it is typical now that someone who started a business 30 years ago, has 100 employees, wants to retire, and would love to sell the business to their employees, their senior managers. And their senior managers say, no, I don't want to own your business. I'll manage it, but I see what it does to you. The liabilities of operating in a highly regulated state like California. No, even if you make me a deal, I don't want to be an owner. So that construction owner with 100 employees tries to sell to someone else with 100 employees. They don't want to grow for the liabilities. So they wind up going to a contractor that has 1,000 employees and says, will you buy my business? And they say, yeah, I'm not looking to grow, but we have full-time attorney on staff. We have full-time unit of HR. We have attorneys on retainer to deal with separate attorneys, specialists in Cal OSHA, workers' comp, environmental issues. And so we can absorb this without incurring greater liability. And so suddenly the 1,000 employee company is 1,100. And they increased market share, not because they were looking to grow or were trying to abuse anything, but they were the only party with enough infrastructure to manage a business in California. And if we don't include that perspective here, we could have the unintended consequence of that business with 1,000 employees saying, I'm not going to grow because I could step into antitrust issues, or my attorney will advise me it's a liability not worth the hassle. And those 100 employees will have their business shut down and have to go look for work elsewhere. So I think we need to understand market consolidation is not just from unfair business practices. And, you're talking about some of the giant arenas, but there's over 1 million small and medium businesses in California, and they need to be considered in this, not to have the unintended consequence of them making it even harder to grow or harder to sell their business when they're ready to retire, to keep their employees working when they go through that. So thank you for the opportunity.
Thank you. Thank you.
And the next speaker is Lee Hepner. Lee.
Yeah, hello, good afternoon, everybody. My name is Hepner. I am senior counsel at the American Economic Liberties Project. I'm actually on the East Coast right now. I just spent 9 hours in court at the United States versus Google antitrust case. And I've been trying to tune in back and forth. But if anybody is of the impression that the status quo is working, that case presents a very different version of events. That is a case where Google, one of the largest companies in the world, is spending tens of billions of dollars to lock up distribution channels for their search engine, to prevent innovation, and to decrease the quality of their own product. California is home to several of the largest companies in the world. The San Francisco Bay Area itself is home to Apple, is home to Google, is home to Meta. These three companies are each facing sweeping antitrust lawsuits now, brought by the federal government and a number of states, including California. This is the status quo is certainly not working to confront the largest monopolists of our time, and that spans industries. It's not just the tech industry. I am very proud of the submission from the California Alliance for a Fair Economy, which was submitted by American Economic Liberties Project, where I work, and about 24 other organizations. I encourage this body to engage with that document. In particular, the comments that we provided about the abuse of dominance model. There are several other states that are moving forward with dominant legislation. California would not be the first to move on such a standard. And I think it's really important that this commission use the time it has to monitor the development of those legislative proposals, not just in New York, but in several other states across the country. We also, I think, engage productively with the working group report on single firm conduct on key issues like the rule of reason, where we agree that that framework, the rule of reason framework, contributes to a lack of certainty in the law and undermines enforcement of the law. And I think that we provide a pretty thoughtful counterproposal to narrow the scope of discretion in the rule of reason that reflects some existing law, but would be a big step forward for California law, namely to limit consideration of pro-competitive justifications outside the market in which anti-competitive conduct is occurring. And we explain that a little bit more fully in our brief. I am very encouraged generally by the single firm working group report, and I'm proud of our substantive engagement with it. I am taken aback at the letter submitted by the Chamber of Commerce, or several chapters of the Chamber of Commerce, and would encourage this commission to approach those comments with utmost skepticism. These are representatives of the monopolists. The reason why Google itself is not commenting on this is because they are a member of the Chamber of Commerce, which is doing their work for them. That is the wolf in the hen house, and I do not think that this commission should engage seriously with the comments of the Chamber of Commerce or ITIF, who seem to think that the status quo is adequate in advancing the rights of workers, small businesses, and consumers across the state of California. In closing, we are a tremendously prosperous state. Our economy is a beacon of innovation around the world, but it is also remarkably threatened by the control of a small number of very large corporations. And I think that if we want to remain at the forefront of innovation and small business innovation in particular, we should protect our economy. We should protect consumers and workers and small businesses from the harmful conduct of monopolists who are threatening to set us back. And I'm so proud that this commission is taking steps in that direction. Thank you very much.
Thank you. I believe we have one more comment, and then we'll close this section of the agenda.
Yes, and the last hand is a speaker we already heard from, so it's Bilal Syed. Not sure if that hand is just left over, but I have allowed Bilal to speak. And we'll give a second. I think that might have just been a leftover hand.
Okay, I think that does it for this agenda item. Thank you for staying to the very end, Mr. Campbell. We appreciate that. Thank you for your useful input as well. Now, we have a couple of other agenda items. We'll take a short break. But before we do that, are there any comments from the commission about the framework of what we've just done? We have a couple of other sessions like this on other topics, and we'd like to mold them to suit what you think is useful. This was the experiment. So are there any comments on the experiment or any suggestions about the next couple of these?
The only thing that occurs to me is we all had a chance to read the the reports, the memos that had the working group report, and so maybe the working group reports could be a little more summarized than going through the details again that we've and hit the hit the highlights and the conclusions, and we can have a little more robust discussion as opposed to just listening. That's the only thing I can think of.
I thought it was substantively it was excellent. I mean, really drilled down hard. My only comment is a slight comment. Maybe it's related to the venue. I just had trouble hearing at various points. It was really difficult to hear at some points, and that adds to the exhaustion. So if we could just work on the audio portion, I think that would be helpful.
Yeah, I think we're not going to be here, right?
Right, but in whatever context, wherever we go, because there are parts of the discussion which was just really, you had to strain, unless I'm getting old or something.
No, I agree. I think there was an audio problem, and a couple of our speakers were very soft.
Right.
Cheryl, do you have comments on what you witnessed or suggestions for the next couple of sessions?
I don't know whether the commission wants to lift on the working groups. Obviously, there are some issues with respect to the but
I mean, Cheryl, can you come over to the mic? We're having trouble hearing.
Yeah, audio problems. Yeah.
Just talking about how we all can hear. Oh, yeah, you can stand at the podium.
I don't know, we were talking about whether there should be some time limits on the working groups. And maybe that was a function of the concentration working group going a wee bit over time, like a lot of wee bit over time. On the other hand, these groups have put in almost a year of work. So I guess I really wouldn't advocate for strict time limits.
Yeah, and I wasn't suggesting limiting their time. My suggestion was more sort of condense their presentation, because we will have read their working group reports already. So condensing the presentation to hit the key points that your conclusions or whatever, and leave us more time to have a discussion and to ask and answer questions. So that it was the interaction that I thought.
My reaction is exactly the same. We had a lot of talent, but we spent most of the time hoping they would stop talking. Frankly, because it's a working commission, people read the materials, and I myself was leaning forward. I wanted to get them into a conversation and out of the presentation. And I think that's what Commissioner Simpson's saying as well, that if we let them know, they should assume we have read their material and are interested in a very interactive. They can participate in the interaction, perhaps even by the working group identifying a few inflection points or controversy points to focus us on, which would then draw us into the debate with them, rather than having them essentially outline their reports for us.
Well, obviously, a time limit would require the group to focus on the more controversial points. So that may have a very therapeutic effect by asking them to please limit it to X amount of time.
Maybe, yeah.
I don't know.
Or if, depending on the group, if we ask the group to identify, if there are 4 speakers, what are the 4 most controversial moving parts? Each of you present one, and that will draw us into a debate about what they think are the inflection points or the most important points in that particular chapter.
I think we
Mr.
can
Chair.
reinforce with the groups that the commission will have read the reports. I think that was unclear to the groups before they came here today. And I think with the next coming groups, if we tell the groups that and ask them to maybe give us a synopsis of what they plan to present, might help to crystallize the conversation.
Yeah, we'll leave that to you and staff to work out. I think the commission seems generally aligned on this.
Mr. Chair, may I speak?
I thought it was very useful. I thought, though, that we missed opportunity for the commission to really dig in and probe and try to figure out what are the moving parts we really need to wrestle with.
Test 1, 2.
Would it be helpful to perhaps present the panels with some questions beforehand that you would like addressed?
Commission?
Mr. Chair, may I be heard?
Who is, is that Commissioner Correa?
It is.
Absolutely.
Yeah.
We didn't notice you looming behind us.
My head's so big, how could you miss me?
There you go.
2 points. One is I agree with you and Commissioner Simpson that the interactivity is the most useful to me. So I was going to suggest that we style this as the way an appellate court would oral argument by saying at the outset, we have read the briefs. And we'd like to engage in a discussion about that. The second point is that something that came up during one of the presentations flagged for me what I find to be most useful, which is the recommendations. So, similar to assuming that we've read the briefs of the presentations and we're most interested in the interactive part, I'm most interested in the suggestions from the various working groups about what they think we should do. Which to me would lead to, after we've gone through the various working groups, I think it would be super useful to have one final plenary session where each of the working groups identifies a representative, and we have one representative from each working group on the panel, and then we have one big Lollapalooza session where we go through a series of proposals to move towards something that resembles a draft.
I think that presents a little bit of a challenge to some of the working groups who took to heart the admonition that they were not to make any quote recommendations.
Yeah,
And
I understand that,
a
but
lot of
we are going
times
to have
that
to
was
move
phrased in
towards a
terms
draft
of
at some point, and I am interested in what they would recommend.
Yeah, I think then we should be very specific and say, we would like you to come up with the recommended. I think that's a great idea. There should be sort of I don't know, almost a kitchen cabinet from the working group to guide the process forward.
Right, and it's not to exclude the other people who aren't the representative. They can all be in the audience, and if there's a point of contention, they can all leap out of their seats, and we'll have a fight about it.
Absolutely.
But, we do need to start funneling this at some point.
Yes.
Yeah. Good. Well, this is all very useful. Any final comments on this? Staff and Cheryl have heard what we've said. We'd like you to decamp, not today, but decamp and sort out how we focus the next couple groups and then what the end game looks like after we've heard each of the working groups present to us. Okay?
I don't recall, is there does the legislature set a time limit for us to give them their recommendation?
No, there is not a time limit.
Okay.
Thank goodness, because this is a big one.
Very good. Thank you, Cheryl. We know you put in a huge amount of work on this. It's paying off. Thank you.
Thank you.
And frankly, it's the first commission hearing since I've been back on the commission that feels normal to me, which is I have a crushing headache and we had a lot of public comment. Let's take a 5-minute break just so people can use the restroom. And then how much work do we have left, Sharon?
We have some presentations related to the Equal Rights Amendment study and landlord tenant. I anticipate that they will be brief. We have not taken up commissioner suggestions yet, and we have some legislative program updates, which can be super brief.
So we're looking at 45 minutes
I would say at the most.
when we get back. Great. Thank you. In recess.
Just need to get that location.
Oh, Victor, were you here when we killed two of the meetings? Why don't you tell him right now so that he knows?
He's executive director. He's
September meeting in the November. Okay. Okay.
Yeah, they're off. All set?
The other one just stopped.
Back on. Landlord tenant is next. Is that the deal?
Yes.
Proceed.
All right. So in this matter, the legislature has asked the commission to study multiple topics relating to the very terminology used in California statutes to refer to parties to residential real property rental agreements. The commission has already considered.
Pull the mic a little closer.
Sorry.
We're losing you in the cavern.
Great, thank you. I can't hear there, now I do, okay. So the commission has already considered the first of these topics that the legislature asked us to study, which was the feasibility of revising terminology in existing code sections to make it consistent while still preserving all legal distinctions between the terms that were used. Today, the staff will present on two additional topics in this study. Memorandum 2024-19, which I will present, addresses the use in California statutes of the specific terms landlord and tenant and terms related to tenant. And then Memorandum 24-20, which Sarah will present, addresses landlord tenant terminology in other states' law. And so let me just get to my notes. So Memorandum 2024-19, which also has a supplement, which is just a letter of support agreeing with the staff recommendation in the main memorandum, responds to the legislature's request that the commission study whether the use in California statutes of the terms landlord, tenant, and related terms, which include co-tenant and subtenant, continue to be useful and appropriate in code provisions that involve the rental of residential real property. The legislature in the bill did not further elaborate on what it meant by the term useful and appropriate, but there are some committee analyses that address this, and staff's conclusion was that what the legislature was asking was whether the terms were sufficiently outdated and or offensive based on class and gender connotations, that the use of those terms should be discontinued. So the staff attempted to weigh the pros and cons of the continued use of these terms as best as possible. As explained in the memo, and I won't go through it in much more detail than that, while the staff certainly does not intend and hopes not to diminish in any way the legitimacy of the expressed concerns that have just been mentioned, particularly about the gender and class-based connotations of the term landlord. It's the staff's conclusion that at least at the present time, the pros of continued use of these terms in existing code sections pretty clearly outweighs the cons that have been identified to this point. In very brief summary, the two terms landlord and tenant, which are the key terms, which are sort of the subject of this question, are extremely well established, both in existing statutes, existing case law, contracts, self-help guides, which often individuals need to resort to in this particular area of law. They are also regularly used in other states, all other states in the country. And there don't appear to be any readily available substitutes for the term where we could avoid the confusion that would happen if we were to replace these terms with two other completely different terms. For example, you know, replacing chairman with chair, that might not be confusing, but here it appears that we would need to come up with different terms. As far as we can see, every other suggestion we've seen has involved completely different terms, like housing provider instead of landlord or something like that. So the staff's ultimate conclusion is that, at least at this time, the use of these terms does continue to be useful and appropriate. And that would be the staff's recommendation, that the commission make that finding. Questions? Yes.
Yeah,
Commissioner Simpson.
I generally agree. My only question was, I was wondering if there was an analogy to, you know, chairman and chairperson or just chair. With landlord, would it be possible to say like landholder? You might not have, you might avoid the confusion of landlord to lessor or that sort of thing. It doesn't, I think, have the same class and gender connotations as lord, male, and, you know, some superior class. And you know, if the legislature was concerned about the as I say, you know, long-standing class and gender implications of landlord, maybe landholder. I was thinking landowner, but that implies a necessary. You also have, you know, your manager for a property.
Exactly.
So I was just wondering if, just to throw it out there as a possibility.
Well, you know, the staff did searches for other possible replacement terms. For example, I mentioned in the memo that in Ohio, they actually tried a bill. They were going to have a bill that would have replaced landlord with housing provider, I believe. And we looked for other terms that might have been used elsewhere as potential substitutes or even suggestions. Part of the problem is that landlord is presently defined in many different code sections in California, and it means more than one thing.
Right. And that
So-
was with the first half of the study.
Right. And actually, landowner was not a term that I searched for personally. Like now, without internet, I can't tell you whether that's already a term which is used for some reason in existing statutes. That was another complication, though, was that if we were to replace either of these terms with another already existing term, a term that was already being used, it meant something different.
Right.
So then you have more confusion. You know, depending on what the commission thinks, I mean, we could look into that. It is,
It was just a, you know,
Well, what was the suggestion, landholder?
landholder.
Well, from someone who works as a public entity with all sorts of overlapping interests over our properties, the problem with the phrase landholder is, what possessory interest are you holding? Is it an easement?
Yeah.
Is it
Is it a fee
you know,
simple?
temporary rental? Is it a actual long-time possessory interest? Is it an adverse possession? I mean, it just goes on and on. Holder
Trying to
just
come up with an analogy to chair and chair.
Yeah,
Right.
I had the same impulse, focused on owner and renter, but it's the thicket of definitions and
Yeah.
different possessory interests that kills that.
right.
I'm speaking for myself, I'm happy with the recommendation. I'm a little not fully happy with appropriate. In my view, it's useful and not
Yes.
inappropriate.
We could, so the next step in the study would be to prepare, I believe that after Sarah presents, depending on what the commission has to say about what Sarah presents, the next step probably will be the presentation to the commission of a draft report. It would be a tentative report, which we would then put out for comment. And so there will be another opportunity. You'll see sort of more of an exposition of what these issues are in the draft tentative report. And there's enough time, I think, we have to look at the meeting schedule, but to tweak that potentially if you find that the explanation of this could be shaded a little bit. Like, for example, something like that. Like we will take note of that, and maybe we can sort of soften or maybe not even, or maybe we conclude, we just say, we believe it is useful. I don't know if we want to say we think it's useful, but not appropriate, because then we're sort of answering their question only halfway. But maybe we can sort of soften the emphasis on appropriate.
And all you need from us is to advise, we're happy with you taking this general approach for the next memo. Is there any commissioner who disagrees with that? Sold.
Excellent. Thank you very much. Wait, I'm sorry, Commissioner Carrillo. Did you, I thought I heard you say something, but okay, thank you.
Nope, good to
All
go.
right.
I was just
Thank
agreeing
you.
with Victor that possessory interests are various.
Excellent. What's next?
Good afternoon, Commissioners. I'm presenting Memorandum 2420, Landlord and Tenant Terminology in other states. So this builds off of Steve's presentation, and a portion of the request was for staff to look at the terminology used in the laws of other states to describe parties to a residential property rental agreement. I chose, well, in collaboration with Steve and Kristen, chose New York, Massachusetts, Illinois, Texas, and Florida. And as you can see from the report, they vary in terms of consistency. But the dominant terms are landlord and tenant, followed by lessee, lessor, and owner. No state was entirely consistent in defining or using terms throughout their codes, similar to California. With New York being the least consistent and Florida was the most consistent, most likely because it reorganized its code in 1973 based on the Uniform Law Commission's Uniform Residential Landlord and Tenant Act. So if you go through the report, you can see that there are multiple terms, lessor, lessee, sublessee, holder of an underlease, occupant other than the owner of any building on the premises. It really varies throughout the states and depending on the individual contexts. So I think it's difficult to take any lessons from the other states, except some solace in the fact that they are similarly disorganized and still striving to find organization under this parameter. Would the commission like staff to do further research into other states' laws? You're welcome. Any questions?
You're done.
Thank you.
All right, thank you.
Good afternoon, Commissioners. Just take a moment to get situated. So there are two memoranda today before you on the Equal Rights Amendment study. I will be presenting the first memorandum 2024-16, which provides an initial draft of proposed legislation, and Sarah will be presenting the second 24-17, which discusses the second phase of the study, identifying and remedying specific defects in California law. So for the proposed legislation, the main goal was to start sort of putting in concrete statutory language some of the decisions, direction that we've gotten from the commissioners previously. The draft language was not seeking to break any new ground, but just reflecting sort of what we had as the sense of the commission and some of the decisions before. So we wanted to get some feedback from the commissioners on the current approach and the language. I'm going to move through the specific items rather quickly, and we don't need, I think, a formal decision on anything unless the commission wants to provide it. But if the commission, any of the commissioners are interested in staff bringing back more detail, some variation, that would be helpful to know so that we can kind of build this proposal out a bit further. So the first issue that the memo addresses is the scope of the rule. The anticipated approach would be that the rule would be codified in each code and apply to the entire code. The draft language in the comment indicates that there are identical provisions, so it's trying to draw people's attention to the fact that this is actually intended to apply not just across a single code, but across all of California law. One question for the commission is whether or not they'd be interested in seeing a notwithstanding clause added to the proposed language. We did not include that in the attached draft just because it wasn't something that we felt like we'd had much discussion on. But I'm concerned that was raised at the prior meeting was that it was possible that there might be conflicting language. We haven't identified any direct conflicts yet, but the question would be whether we would want this rule to apply, notwithstanding any provision to the contrary. Any feedback from the commissioners? I'm seeing some thumbs up. Commissioner
Yeah,
Singh?
I think we should. My question is, rather than amend all 29 codes or whatever it is it possible to do an uncodified statute that applies to these 29 codes with the same language, the same notwithstanding?
So I think the first thing that jumps out to me would be the concern that it might get lost for people. And that would be my concern about an uncodified provision is might be harder for lay people to find in the law. And so that might just be a trade-off to consider whether or not, because it is, I recognize codifying it in each code is a lot.
Yeah.
Where would you put it?
And where would you put it? Yeah. And numbers and all that sort of stuff. So
There's
it's just a thought.
Well, and yeah, if the commissioners would prefer to go with an uncodified provision, that's something that could definitely be done. I mean, the statutory language could look very similar and we could just do a single uncodified provision.
I think that would be difficult for people, like, as you mentioned, people to have clarity on what is out there. I think it's risk of confusion.
Yeah, the initial idea of putting it in all the codes was just simply to make sure it draws more attention to that issue when it's in the annotated code books. Also, the commission's comments are reproduced so people can find them more easily. I don't know what would happen with commission comments for an uncodified section and whether or not those would be, like, people could find those. I'm not sure whether the annotated codes would include those anywhere, so.
I did have one question, whether staff, I had, obviously my staff look at the language, and one question that came up is whether it was considered that this could be, this kind of broad language could be interpreted as an improper amendment by reference in violation of Article 4, Section 9, which basically says a section of statute cannot be amended unless the section is reenacted as amended. So I don't know if we've considered that, just something to have in mind if we do decide to proceed with this approach. We might want to consider picking the provisions that are, more widely known or have the most impact, and include some type of cross-reference to this general provision so that it's clear that it was intended to apply to those statutes.
Okay, so yeah, so the broader ones, we did borrow a lot of language from those, and like this provision is largely consistent, but it does go a bit further and includes some more express language. We have not considered whether or not this would be an improper amendment. I made a note of that, and that's something that we can look into, but yeah, so I appreciate that feedback.
Thank you.
The notwithstanding language deal with that?
And we don't think so. It's
Oh,
too
yeah?
broad. It could be challenged, I guess, so
Okay.
to be safe.
Yeah, so we'll take a look at that and bring that back.
Can I, maybe a question for you? What would happen if we have this language that's supposed to supersede anything in conflict with it elsewhere in the code, and 2 years down the road, there's an amendment to the language that's been superseded by this that, doesn't make it consistent with the code-wide one? Would that then be in effect?
Supersede the,
Superseding
the language. That's why I think, to be clear, we would want to include cross-reference to make sure that, anything that is clear what the intent is.
Yeah.
So, and I'm sure that would be raised when the amendments were brought up.
Is that something we could follow up with the staff in your office about if we have questions? Yeah, because appreciate that. Any other questions from commissioners at this point? All right, so I did get some general positive feedback on the idea of a notwithstanding clause, so we can look at that. And the next issue actually is the language of the rule itself. So one initial note is there was a staff proposal to just make clear that this applies to both sex and gender discrimination. We've been talking specifically about sex, but California codes generally use those terms a bit interchangeably. So we want to be clear that if the provision says gender discrimination, we are also intending this rule to apply. The heart of the proposal is really what is sex discrimination, and there is a list of characteristics that are included in the draft. Those are reproduced on pages 3 to 4 of the memo, A through H. In this initial draft, we strove for brevity. We were trying to keep it brief, but we also wanted it to stand alone. So there is not a lot of detail on what we mean by the specific items in the list. There are not definitions. In one case, we did import some language from another code section to help make clear what that term was. That was the reproductive health decision-making. But we wanted to get the commissioner's feedback on whether or not this level of detail was appropriate, whether or not the commissioners felt like we should actually be trying to provide more definitions here about what is included in each of these individual items. I did want to mention that most of these were drawn to some extent from California's existing statutory law, but there were some where there wasn't as close a direct analogy. Those were the prongs in subparagraphs A, B, G, and H. So that language, there were some things that we drew from, but they were not necessarily in the discrimination laws. And so they were kind of, I think, taking things a step forward in terms of the express language of discrimination laws. And I'll just note that the language also specifies that the discrimination could be based on actual or perceived characteristics, and that discrimination includes harassment. Several months ago, the commission considered the idea of sex plus discrimination, which is something that came up in the federal law, and that was something that the commission found would be within the scope of its study. There wasn't a really straightforward way to address that, and it also relates to a pending bill that is on a somewhat different issue, but a related issue about intersectionality. So we didn't have language that addressed that specifically, but I did just want to note that in the federal case, at least, that was considered to be covered under just the term sex discrimination. So I welcome any feedback from the commissioners on whether we should provide more detail, if there's any issues we should address directly that we haven't, or any other concerns about the language.
I was just pointing out that in sub A, it includes gender, and then sub C also references gender. I'm not sure if that was intentional, or if there's a difference that might not be obvious.
Yeah, so that gender is part of a gender category, which is actually something that we found is used on California identity documents. So it is sort of referring to a specific marker on identity documents in sub A.
I see. So it's more of a how you identify versus.
I think like on your driver's license is your gender category, that's from the driver's license laws, I believe.
I see. Okay, thank you.
Any other questions, concerns? Okay. So the next item the memo addresses is non-exclusivity. So this is an issue that has definitely come up a number of times for the commission. We included some language that specifies that it includes sex discrimination includes, but is not limited to. The rule also includes the language also includes a rule of liberal construction, and the comment language indicates that sex discrimination includes, at a minimum, discrimination based on the listed characteristics. The staff was hoping that that might address the issue, but we welcome feedback on the commissioners if they want something more to do that. Hearing Hearing none for now. All right. One issue that we came across as we were drafting was the idea of associational discrimination. So California's broad anti-discrimination rules expressly cover situations where the discrimination is not necessarily directed at the person themselves, but instead someone they associate with who has the protected characteristic. In this case, this probably is just covered by general law and did not necessarily feel like something that we needed to incorporate in this rule, but we wanted to get the commissioner's feedback on whether or not that was something we should address here too.
Just so I understand, associational means you're with somebody who's protected, correct?
So the idea,
I'm talking about because you're with them, you are perceived to be the same as?
no, my understanding is it's just that the discrimination is actually sort of targeted at one of your associates. So you're being discriminated against because they see your roommate and your roommate has a protected characteristic that they don't like. And so you're not necessarily perceived to be the same, but so I'm not hearing any clamoring on that point. So we will set it aside. If it's something that we want to come back to, I think that's fine. We just wanted to raise it because it seemed like something that we were coming across quite a bit. The other item that the language includes is it specifies a relationship with constitutional provisions. And this stemmed in part from a prior idea presented that we might want to specify that this rule was in service of existing laws and requirements. Here, we were trying to make clear that this rule would is in service of these different constitutional protections. This also helps give a little bit of weight towards the idea that it should be liberally construed in favor of those constitutional protections. So it's a slightly different approach, I think, to similar ends as to where we were trying to get to in the previous memo, but we wanted to just hear from commissioners on what they thought of that language, and whether or not they are interested in pursuing that approach or not. The other thing I just want to note is the citations that are in the draft language were not intended to be in sort of the final form. That was just intended for reference at this point.
Kristen?
Yes, Commissioner Carrillo.
In general, agree with one big caveat, which is that I think we should refrain from referencing federal law, both as a general principle. I think California law should effectuate California's constitution, and federal law should effectuate the federal constitution, and not each other in general. I specifically would have trouble with linking us to statutory federal law, which could change in this context and it could be different from what we're trying to achieve. So I wouldn't want to do that. And then there's also the additional problem with referencing the Equal Rights Amendment, because there's a substantial question about whether that's a thing or not. So I wouldn't want to be connecting us to something that's at best amorphous in federal law. I would leave out any references to federal law and only include the references to California law that you already have.
Okay, and I believe that, so that's specifically in the draft comment language, because I know that includes a reference to the ERA. So
yeah, and then in the memo also talks about referencing Title VII. So which is not in the draft, but I wouldn't add it to the draft. I would leave that out, and I would take out the reference to the ERA.
Okay.
I personally think that it's valid, but Congress hasn't said so yet, so it's in limbo.
Any other comments?
So I guess my question is whether or not, if we include these references to the California Constitution, if they could be perceived as more limiting than the ERA, and whether that sort of, goes against our charge as a commission.
So, yeah, I think, it is a bit challenging to figure out. There's a lot of arguments as to how far the ERA might go and sort of whether or not it would be a significant sea change in sort of how we view equality. And certainly, I think that might be, that it's hard to predict. And, you know, in the absence of having some more concrete ideas about how the ERA is going to be implemented, that's a difficult question to answer. So, you know, we did find that California's constitutional protections generally do extend quite broadly to many of the protected categories that we were concerned about covering. Now, whether or not the sort of concept of equal protection that underlies, I think, both state and federal law might shift with the ERA, that's a much harder question to answer.
Kristen, to address that concern, what would you think about importing at least a little bit of the language that's in the memo, but it's not currently in the draft comments? And I'm specifically looking at page 6, which talks about the rule being intended to implement the protections of the California Constitution, that it's derived from them, but not by way of limitation, which leaves it to the courts to expand them if necessary. So it establishes a baseline, but it doesn't limit it to that.
Okay, yeah, so I mean, perhaps like shifting the language that instead of saying it's intended to implement, that it is derived from, which helps kind of give it a bit of a life of its own. Yeah, I think it may be that we can kind of wordsmith the language somewhere along those lines and get to a bit happier place.
Yeah, because I liked what you said in the memo. That made sense to me, but the draft doesn't quite capture what's on page 6. So I think to address Kara's concern, if you added a little bit of the flavor that's on page 6, I think that would go a long way towards it.
Okay, yeah, thank you. No, I think that gets us to a much better place on that point. So I appreciate that input from both of you. Thank you. And I think that addresses the sort of language of the rule questions. This issue was kind of flagged earlier in the discussion, the idea of where are we going to put this rule. So in each code, the idea would be it would probably go in something like general provisions, preliminary provisions. The staff did check, and all the codes have some container or containers that have, you know, a name along those lines. In some cases, it might be combined with definitions or rules of construction, but those would seem to be the appropriate place for a rule like this that's intended to apply code-wide and to, you know, quasi-definitional about how you should understand the term sex or gender discrimination. An idea that we had that would, you know, maybe make the connection between all of these different provisions a little bit more clear was that they could have all the same section number. I think in our research suggests that might have been a little too cute and a little bit too hard to implement and would have required some illogical placement for some of them. So that is not something that we would propose doing, but we just wanted to raise that idea as something that was considered and dismissed. And then finally, the draft includes comment language. The memo describes the contents generally, and I know Commissioner Carrillo has already made some comments about what we've included there that we can take into account. We do intend to expand the comment language to address the language in proposed subdivision C, which is the relationship with the California constitutional provisions, and along the lines that we've described, that will be revised, and we'll try to develop comment language that goes along with that. And I guess just wondering if there's any more feedback on the level of detail in the comment language or any other specific adjustments we should make.
Hearing none.
Seeing none.
Thank you for the excellent work. This was a difficult project to get your arms around.
Yeah, and then, yeah, I think we're finally getting to the more concrete phase of it. So we'll be working towards some legislative language. I may be in touch with you, Commissioner Jenkins, if there are some questions about some of the issues that you raised. But we appreciate the feedback of the commission, and we'll be working on this and hopefully towards a draft tentative recommendation to implement the proposed reform.
Thank you.
Thank you.
Good afternoon. I'm presenting memorandum 2024-17. This is the second portion of the Equal Rights Amendment study. My memo presents an update in the next steps in Part 2, identifying and remedying specific defects in California law. After the introductory material, there were 3 brief case updates, and in the interest of time, I'll skip 2 of them, but I would like to highlight the third, which relates to the assertion of religious rights in the context of abortion laws. Here, the Indiana Court of Appeals sided unanimously with plaintiffs who contested a restrictive abortion law, stating it violated their rights under the state's, this is Indiana's, Religious Freedom Restoration Act. Notably, one of the plaintiffs did not affiliate with any religious organization and did not believe in a single theistic God. The other plaintiffs identified with the Jewish faith. And the court used reasoning parallel to that in Burwell versus Hobby Lobby stores in cases enjoining the COVID-19 vaccine mandates. So to the extent that any of you are interested, it's a very interesting case to read, and it sort of flips a lot of the arguments that we've been hearing within the scope of this study. Highlighted that there. Following these updates, the memo moves to the second part of the ERA study, which directs the Commission to evaluate existing California law to identify and remedy provisions that have discriminatory language or disparate impacts. For discriminatory language, as noted in the prior memos, California's laws are actually in fairly good stead as to policies and language protecting equal rights. However, California law does retain instances of gender-biased language, which is a type of discriminatory language. And on page 7, you'll find a chart of some gender-biased terms and possible replacements. And this is kind of a nod to the chair/chairman comments that were referenced earlier. Does the Commission have any comments or recommendations for additional gender-biased terms and possible replacements?
Well, I don't see the term landlord in there anywhere.
I was doing my best not to intrude in other active studies of the Commission.
I'm just saying.
So I have a question. It's
Certainly.
just, is the purpose of this to make a recommendation to the legislature to make these changes, or?
That's what I was moving toward. If the Commission was interested in staff moving forward on likely not all, but a subset of these code sections to neutralize some of these terms.
So I will, and this is sort of
Yes.
an issue that's near and dear to my heart is, and I just wanted to point out that our agency is already kind of addressing this in response to, I think it was ACR 260 from 2018, which the legislature essentially directed us to have gender neutral language. So we have been changing these gender biased terms as we create new statutes. And if we're amending statutes that have this language, we routinely will update them. So I don't know if this is duplicative of what's already out there.
Yes, Commissioner, and thank you for recognizing that. And I noted in one of the footnotes that we realized that it is part of legislative policy. It does seem like it kind of comes up as the bills come up. So there may be instances where if we decided to maybe tackle some of them sooner than would otherwise be taken care of, that would be, the commissioners may consider that an option.
And I will say that, I did ask, if we were asked to take on certain codes and try and do this, it would be quite a huge task to do this. Even I said, what if we had 100 instances that we need to change? And it sounds like it would be quite a task. I know it doesn't sound like it, but that's why the decision was made to kind of do it as it comes up.
As those sections come up.
Yes.
I defer to your expertise, Commissioner.
If we haven't moved on from the chart, I'm a little uncomfortable with exempt for the grandfather thing. It seems to me the concept needs to be more of a phrase. Why the exemption takes place, by virtue of what, as opposed to just being exempt. Because there's a different nuance. Grandfathering is exempt by virtue of longstanding, and that's different than saying you're exempt. I don't have a solution. I just want to point out that when you tell me a law is exempt, I think it was exempt for a policy reason or an inherent distinction in the things that you're parsing out. But the concept of grandfather is that it isn't exempt, but for the fact that it existed before. So it seems to me exempt doesn't capture it. It might be exemption by, pre-existence. That's awful, but something like that, I think it needs to be stretched.
And I think perhaps that goes to the commissioner's comment that this is possibly a mightier project than initially recognized. And so going forward and remedying them as the bills come through the legislative council may be the more appropriate venue for these corrections.
But I wonder if other states have dealt with that issue, or if we're just so progressive, maybe we're the first people who looked at it.
I have not looked into that further, but
Okay.
the resources that I went to sometimes did mention grandfathering, but they didn't pinpoint any other states particularly that had used or decided to change that term going forward.
Could we leave that one out because it's a legal term of art?
Certainly.
Yeah, because everything else is kind of like a pronoun or like a noun, and
Yeah.
and the exempt isn't.
You can also, it can also be addressed by identifying that your chart refers to actual people, not to temporal concepts.
That's a good point.
Excellent. With this discussion, would the commission prefer going forward, perhaps this chart to move forward as a general recommendation without staff undertaking the actual amendment of the laws? Does that sound like the appropriate next step for this process?
What would that mean?
Suppose in the final report, the commission would recognize these particular terms as opportunities for revision in the future when the legislature goes forward with its gender neutral revisions, but it's not something that the commission would like to do at this time.
Well, yeah, so there was an opportunity here that we could report to the legislature on where these terms exist. Now, what that would probably mean is at the next step would be someone would need to do it. So that might fall in Commissioner Deacon's lap. So I'm a little, that makes me a little nervous, given the scope of the task. So yeah, I guess the question would be whether or not we take on a subset, whether we simply identify the issue and leave it undone, whether we make a recommendation for, we identify the issue and make a recommendation that it be done, and we could even identify ourselves to do it. Now, maybe we don't want to take it on initially, but yeah, again, with the scope of the task, it may be that it's not really something that we want to push off onto someone else's plate, or even that we think, we want to bring onto our own plate because, over time it will be happening. So it's just a question of how do we want to proceed with this?
Well, that's the decision. What's the sense of the commission on whether the chart moves forward from us or the chart sits where it is until statutes get naturally revised?
I'm sure we have a much larger list. And I feel like we're already making these changes, and I'm not trying to, say that we're not willing to do any more. I do feel like, a lot of like the chairman to chair, those types of things are already being done. So I don't know if it's really valuable for the commission to continue on, kind of developing this chart and proposing anything to the legislature when we're already kind of actively making these changes.
I think a chart for our internal use makes sense. I would hate to duplicate a project that's already underway somewhere else, though.
Especially when we're working on this antitrust thing.
True.
True.
And if there, if we're in some other study and looking at code sections that happen to have some of these terms, we can suggest, these amendment edits to it to conform to this sort of policy.
I think that's the sense of the clear sense of the commission.
Thank you. Shall I say for a decision point that the commission reads the memo and we've decided not to move further on this topic, on this portion of the study? Would that be
Sorry,
fair?
I'm not hearing.
Oh.
A little closer. would
Sure.
help.
For purposes of decisions for this portion of the memo, would it be fair to say that the commission chooses not to move forward with changing the language in this area at this time? And acknowledges the good work of the Legislative Council moving in this area, working.
Yeah, that's fair.
Okay, great.
And we're gonna keep our own lists.
Okay.
So we do the right thing as things come before us.
Great. Thank you. Next, the memo outlines the structure for cases arguing disparate impact and gives several examples. Disparate impact theory is primarily used to challenge practices based on state and federal employment and housing discrimination laws. Generally, a disparate impact occurs when a facially neutral law disproportionately adversely affects members of a protected class. A law fails the disparate impact legal test when there is no legitimate business reason for the law or policy and no less discriminatory means are available to achieve the law's purpose. This is a very fact-intensive process based on the cases that I saw. We have reached out to the stakeholders listed in the exhibit on the memo for assistance in further identifying opportunities where laws exhibit disparate impact. We haven't really received anything concrete so far, but we will keep you posted as more information rolls in. Does the commission have any further recommendations for outreach?
Hearing none, although Sochi probably does. So it would make sense to reach out to commissioners, certain commissioners who are not here, if you think you need a wider network. on this.
Okay.
And that's all I have for this memorandum, unless the commission has any other further questions.
Okay, the couple agenda items that we didn't get to was commissioner suggestions. Is that something you would like to take up, Mr. Chair, or have we done enough of that today?
Oh, we're always open to suggestions.
Okay.
And I
Hearing
find
none.
suggestions at the end of a long day are usually the best suggestions. So,
I suggest
are
we
there any
adjourn.
suggestions for more work? Commissioner Correa?
No, I suggest we adjourn.
I just have one more thing. It's gonna be really quick.
Okay, we have no current suggestions, and we are unlikely to have them until after we have a sense of where antitrust is going.
Okay, great. So the final thing that I just want to bring to your attention, no decision points, is that we have the 2024 legislative program status report update, along with a brief update on the administrative subpoenas. So I'm going to do them both for Sarah and me. The status quo is still going on with AB 522. It's still pending in Senate appropriations. If anything changes, we will let you know. Our resolution of authority has been formally introduced by Assemblymember Kalra as ACR 169, and we thank the Assembly member, who is also a member of the commission, very much for doing so. It's currently pending in appropriations. It made it out of Assembly Judish. We have a little information about some continuing code cleanup related to other studies that have already been issued. And we have a couple proposed new assignments. AB 1906 would create a study on removing the terms dependent adult and dependent person from the California codes. I think that is in appropriations. That's pretty much where things are going at this point of the fiscal year. The detail is set forth in the memo. AB 2125 is a study on recusal of judicial officers. All the information on that bill is set forth in the memo. In addition to sort of the typical work that the Law Revision Commission conducts, it looks like it would require some data collection as well. And so that's all we have for now. Does anyone have any questions?
Hearing none. Thank you, thank you everyone for a very productive meeting, and particularly to staff for all the hard work putting this together. Please be sure to notify the commissioners that we have withdrawn 2 meetings from the schedule so that those who are not here do not ultimately appear. Now, I always forget, do we need a motion to adjourn? Or do we simply drift away?
Move to adjourn.
I think we do take a motion.
Okay.
Yeah.
Is there a motion to adjourn?
Move to adjourn.
Is there a second? Second. Anyone opposed? We are adjourned.
All right, thank you.
Hopefully you did. That's hard.
No.